Courts possess enormous authority. They decide liberty, money, reputation, even family relationships. But that authority depends on one fragile condition above all others. The judge must remain neutral, not loyal to public opinion, not influenced by private relationships, not shaped by online outrage, media pressure, or social media campaigns. Once confidence in impartiality begins to erode, then confidence in the entire system begins to erode with it. I am Polymopicus, and this is Polymopicus Legal. Legal concepts explained for non-lawyers, by a non-lawyer for educational commentary, and is not legal advice.
The legal system depends on trust. Not trust that every case will feel fair. Not trust that every side will win. Not trust that every judge will be perfect. But trust that disputes will be decided by a neutral decision-maker, applying law and procedure rather than personal preference, outside pressure, popularity, or favoritism. That principle is called judicial impartiality, and without it, the legitimacy of the judicial system begins to erode. Because courts derive authority not from force alone, but from public confidence that decisions are being made fairly. Judicial impartiality means that judges are expected to decide cases fairly, neutrally, objectively, and without improper influence. A judge is expected to apply the law consistently, evaluate evidence based on rules, avoid favoritism, avoid personal involvement, and remain independent from outside pressure. Impartiality does not mean judges stop being human. Judges still have opinions, backgrounds, personalities, experiences, and beliefs. The issue is not whether judges have personal views. The issue is whether those views improperly control judicial decisions. Courts exercise extraordinary power. They can issue binding orders, restrict liberty, decide custody, award damages, impose sanctions, and interpret constitutional rights. That authority only functions if the public believes cases are decided through lawful process rather than favoritism or political loyalty. Once people begin believing outcomes are predetermined, judges are aligned with factions, or public pressure controls rulings, then confidence in the system weakens. Impartiality, therefore, protects more than fairness. It protects legitimacy itself. The legal system recognizes two separate concerns. Actual bias. This involves genuine prejudice or favoritism affecting judicial decision-making. Examples may include financial interests, personal relationships, prior involvement, deep personal hostility, or prejudgment of facts. Appearance of impropriety. Sometimes the issue is not proven bias, but the appearance that neutrality may reasonably be questioned. This matters because courts rely heavily on public confidence. Even where actual bias cannot be proven, circumstances that reasonably create suspicion can still damage trust in the process. This is why courts often emphasize, justice must not only be done, but it must appear to be done. When impartiality may reasonably be questioned, judges may be required to step aside. This is called recusal or disqualification. Recusal may arise from financial conflicts, family relationships, prior legal involvement, public comments, personal knowledge of disputed facts, or other conflicts of interest. Importantly, recusal is not always an admission of wrongdoing. Sometimes it reflects recognition that public confidence requires distance from the case. Judicial impartiality also requires insulation from improper private influence. One major concern is ex parte communication. This refers to communication with the judge by one side outside the presence of the other side. The problem is not merely secrecy. The problem is unequal access. If one side can privately influence the judge, neutrality becomes questionable. That is why courts strongly restrict off-record communications, private discussions, and outside factual input regarding pending matters. Modern technology has complicated judicial impartiality enormously. Judges today often have social media accounts, consume online news, encounter viral commentary, and exist inside the same information environment as everyone else. This creates difficult ethical questions. Judges are generally permitted to use social media, but they must do so carefully, because online behavior can create concerns about bias, favoritism, political alignment, or improper influence. For example, commenting on pending cases, publicly arguing political disputes, interacting heavily with attorneys appearing before the court, or engaging with inflammatory online content may create ethical concerns, even if technically legal. The issue is often not, did the judge violate a law? The issue is, could this reasonably undermine confidence in neutrality? Modern courts operate under intense public scrutiny. High-profile cases may involve nonstop media coverage, online outrage, public campaigns, viral commentary, political pressure, and social media narratives. Judges are expected to resist these pressures. Courts are designed to apply law, evidence, and procedure, not popularity. This creates tension because legal outcomes do not always align with public emotion. Sometimes the legally correct outcome is unpopular. Sometimes public narratives are incomplete or inaccurate. Judicial impartiality requires judges to decide cases based on the record and not internet consensus. Social media amplifies several risks simultaneously. First, it creates constant exposure to commentary. Second, it creates public records of interaction. Third, it can blur professional and personal boundaries. For example, liking posts, sharing commentary, following political pages, or engaging publicly with litigants or attorneys can create appearance concerns. Even passive online behavior can become controversial once examined inside litigation. Technology has made impartiality both more important and harder to preserve publicly. A common misunderstanding is that a neutral judge must appear passive, silent, or emotionless. Not true. Judges still manage proceedings, enforce rules, control the courtroom, question witnesses in limited contexts, and issue difficult rulings. Firmness is not automatically bias. An unfavorable ruling is not automatically prejudice. The legal system distinguishes between disagreement with outcomes and improper favoritism. Those are not the same thing. Many people assume, if the judge ruled against me repeatedly, the judge must be biased. But rulings often reflect procedural rules, evidentiary standards, burdens of proof, preservation requirements, or controlling law. Bias requires more than dissatisfaction with decisions. Otherwise, every losing party could claim impartiality had failed simply because they lost. The standard is higher than disagreement. The legal system uses several safeguards to protect impartiality, including ethical codes, recusal procedures, appellate review, public hearings, written rulings, disclosure obligations, and restrictions on ex parte communication. No system eliminates all controversy perfectly, but these mechanisms exist to preserve structural fairness and accountability. Judicial impartiality reflects a deeper principle. Courts must function through law rather than loyalty. The authority of judges depends not merely on power, but on disciplined neutrality in exercising that power. Without that neutrality, courts risk becoming instruments of influence rather than forums for adjudication. Judges are human beings operating inside an intensely public world. They encounter media, politics, social pressure, and online commentary like everyone else. But the judicial role demands restraint. Judicial impartiality is the principle that courts must decide cases based on law, evidence, and procedure rather than personal allegiance, internet pressure, or outside influence. Because once confidence in neutrality begins to disappear, the legitimacy of the legal system begins to disappear with it.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.